Good evening, ladies and gentlemen, and thank you for joining us. As you are aware, every Thursday between 4 p.m. and 5 p.m., the South African Bar Association hosts a speaker to deal with a legal topic intended to assist young practitioners with training and development, which feeds into the core values that we hold as an organization. It brings me great pleasure in introducing today's speaker, which is no stranger to us, Advocate H.B. Marais SC. Advocate H.B. Marais is an expert in many fields of law, and his address today, he shall be addressing us on medical negligence and what must be pleaded. We are grateful to have Advocate Janine Khan to conduct his welcoming and conclusion. In terms of housekeeping, during the address, all participants shall ensure that they are muted. After the address, there will be a question and answer session for those participants that have a question. Kindly raise your hands using the Microsoft Teams platform, whereby you shall be unmuted to pose your question directly to Advocate H.B. Marais SC. With much further ado, I now hand it over to Advocate Janine Khan to conduct the welcoming of today's speaker. Over to you, Advocate Janine.
Good afternoon, everyone, and thank you so much for this. I have been asked to introduce H.B. Marais, an advocate, a colleague, and a friend. It is both an honor and a privilege to do so. H.B. Marais graduated cum laude from the Rand Afrikaans University. He has been practicing as an advocate since 1981 and was conferred silk status on the 26th of November 2009. He is one of the founding members of Innovation Legal. His is a general practice focusing on a broad spectrum of law with an interest in personal injury and medical negligence law. When asked to do this introduction, I started scrambling to find some information on him. And when I realized that he was more elusive than the Loch Ness Monster, I decided to give him a call. And this is what he said about himself. I have 2 children, 4 dogs, an interest in heavy metal music. I love British humor, detest Mount Blanc pens, and when I die, I would like to go the way of Prince Philip on a Land Rover. What he didn't say was that he is a respected member of the Johannesburg Bar, an effective and deadly litigator, and a gentleman of note. He has never been pretentious, and is for me the epitome of everything a senior counsel at the bar should be: respectful, measured, and knowledgeable. As an opponent, he is a gentleman and never fights the person. He is strangely English though, right? Even though he is Afrikaans, and many may not know, but the HB actually stands for Hendrik Bastiaan Marais. So there we go, guys, mystery solved. Without taking up any more time, I have the pleasure and the honor of introducing H.B. Marais. Thank you.
Well, thank you, everyone. Here I am. Janine, thank you for your very kind words. I feel very welcome. You were too kind, but I know you that way. I should mention at the outset that there are 3 preliminary matters that I will be addressing. This is part of the first. I will be dealing with certain aspects, and obviously I won't be dealing with all aspects equally well, but as everyone, both Janine and Ahmed has pointed out already, there will be a question and answer session later on, and then you can ask further questions if that is necessary. I'm doubtful that my presentation is going to carry on for 35 minutes. Janine got my second name wrong. The B actually stands for brevity, so I'm not going to be that long. Okay, let's get to the second set of preliminary remarks, and I will be dealing with the question of pleadings generally. Now, obviously, what I'm doing or I'm required to do is to speak about particulars of claim as far as that relates to medical negligence matters. But I still think that there are a number of aspects that I should raise in respect of pleadings generally, and obviously that will then also apply to medical negligence matters. The first is, and it's important that one should have a Latin phrase somewhere, but the first is Victoria curam amat. Apparently, this was an adage which the Roman army used. It is, or may even have been coined by a Roman poet called Gaius Victorius Catullus. What it means is victory loves preparation. And in the case of all matters, preparation obviously is important, but in the case of medical negligence, that is even more true than in most other instances. There is a certain overlap between MVA matters and medical negligence matters. In fact, the whole question of the calculation of damages coincide by and large. But there's one important difference between the two, and that is that in the case of MVA matters, the Marais really is the easy part. That is how the collision happened. Jimmy didn't stop at a stop street or went through a red light or turned right in the face of oncoming traffic. That is normally an easy aspect. Normally also only takes a morning to resolve if evidence needs to be led in that regard, and it's really the cheap part of the claim. The expensive part of a third-party claim is the fight about the quantum. But that is not the case in the case of medical negligence. There, the biggest part of the fight is about the Marais, and that is, was the medical practitioner or whoever negligent? That normally or can take 5 or 10 days, and a whole variety of experts may have to testify. It is seriously, seriously expensive. The quantum part actually is the easier part to deal with. Now, what happens often is that a claim is instituted, the parties go through all the pleadings, and then they're faced with a trial date. And what often happens is a month or two before the trial date, there's a big scramble to get experts available to testify, and it then often turns out what the case is really about, and it often then turns out that one or the other party actually does not have a claim. Now, this is something that I would suggest you avoid as far as possible. The important thing, and this is where the preparation comes into it that leads to victory, is that the research and the preparation actually has to be done at the very outset. That is long before particulars of claim is drafted and goes out. And then already you have to determine what the case is about, who was negligent, how were they negligent. You already have to have your experts lined up. You need a proper expert report, maybe even more than one. And ultimately, even at that stage already, you have to know exactly what your case is about and exactly against whom you have to institute these proceedings. I'll deal with aspects of this a bit later again. Now, it is not unusual, for instance, in most instances, I mean, that one would send out a letter of demand before the action is instituted. And if you have a case against the state, that is because the negligence was perpetrated by someone in a state hospital, then you still have to send out a letter in terms of Section 3 of the Act, which is called Legal Proceedings Against Certain Organs of State Act. I normally simply call it the Organs of State Act. Now, that notice actually has to be sent out, I think it's 6 months after the negligence occurred, or after you found out about it. But the important thing, as far as I'm concerned, is that even before that letter goes out, it is necessary that you already know what your case is about. It is when that letter goes out, you need actually to have your experts available. You need to have done your particulars of claim, so you have to know what you're going to say ultimately in your case when your letter of demand goes out, so that your letter of demand and your particulars of claim are completely in sync. That's the first preliminary aspect in respect of pleadings generally, although to a large extent it's probably related to medical negligence in particular. The second is relates to the use of precedents. Now, there are three things to be said about precedents. The first is, don't assume that a precedent is correct. The second is, don't assume that you know better than the precedent. You can see already there's a contradiction there. And the third is, beware. So obviously, we all use precedents, and it is a good thing that we do. But on the other hand, I mean, I haven't discovered fire, or I didn't discover the wheel or something. We all use precedents and information that we get from other people. But the important thing about a precedent is that you actually know the topic and that you understand the precedent, and often certain things are said in the precedent that may relate to that specific matter, but not to your matter. So be careful when you use precedents, particularly also when it comes to medical negligence matters. The third preliminary aspect that I would like to mention actually relates to one of my pet peeves, and seeing that I was afforded a platform to be able to speak to people, I'm going to use or abuse this to raise this aspect as well. And that is the question of what your document looks like. Keep in mind that what medical negligence matters is often about the following, and that is, you draw particulars of claim in which you attack a doctor, for instance, for messing up when he or she did a delicate bit of surgery. But if the particulars of claim that you do, if that goes out and it looks like a dog's breakfast, I mean, it really, you just simply can't be taken seriously. We're in a position at the moment where I suppose because everyone had a laptop when they were at varsity and they started typing their odd document here and there, they now also type their own documents when they're at the bar. Now, there's nothing wrong with typing your own documents as long as it doesn't look like it. The position at the moment is that documents just look awful. They just look absolutely atrocious. I think many counsel should be absolutely ashamed at what the documents that they produce look like. Now, in a certain sense, and maybe it doesn't matter, because however bad your document looks, it's not worse than any other one, but it just doesn't look like these documents should look like. For what it is worth, I wrote a little article about this. It's like a 2-page document. It is called Lord Charlie Ariston's Angels, and it is available on LinkedIn. Maybe it can be made available for anyone else who's interested in it. But it's all about the fact that our documents, the pleadings that we produce, no longer look sufficiently professional. Okay, the fourth point relates to the standing or the approach that many people have towards drafting. Drafting often is seen as just a necessary evil, something that we have to do. But it's actually a very important part of practice. It's an important part of particulars of claim that you send out in medical negligence matters. And it is, ultimately, drafting is the prince, actually, of all activities. I don't say that I draft better than anyone else, but nonetheless, drafting is my second best skill. And I think it is important that people take an interest in drafting and try and draft as best possibly they can. Okay, now we come to the preliminary remarks in respect of medical negligence. And here I mention a few things. Most of this must be quite obvious, and most of this you may know already. But the first is that medical negligence claims, by and large, fall into two categories. The first is where the defendant is a public defendant, and the second is where they're a private defendant. Now, the public defendants, those are the defendants where the state is being sued. So it was a state hospital where the event or the occurrence occurred, and your defendant is the state. We'll get back to that. The second is where the person who was negligent was in private practice, and the defendant is therefore a private defendant. Now, in respect of public defendants, let's just have a look quickly at how that works. And that is all the state's medical facilities fall within or under the jurisdiction of the provinces. So if you have a defendant, you're not suing the national government, but a provisional government. It's also an important feature in the sense that all the servants, all the employees at a government hospital work for the state. So the doctors work for the state, and the nursing staff, everyone works for the state. So there's no distinction between doctors and nurses really as far as who was negligent and how that affects liability. The next aspect is that the head of the provincial medical departments is the member of the executive council for the Department of Health of each province. So we'll get to that again. If you sue someone where the state was negligent, you would sue the relevant MEC of the particular department, of the particular province. Right. Let's just deal then briefly with private defendants. The maybe important part here is that doctors are not employed by hospitals. So a doctor may practice from a hospital, and he may have his or her rooms there, but they're not employees of the hospital. They are also mostly individual practitioners, much like advocates. But certain doctors do form partnerships, or they practice in incorporated firms, much like attorneys do. They are often the pathologists and the radiologists who actually have very large firms of pathologists and radiologists. Now, the nursing staff of a hospital are normally employed by the hospitals. So, particularly when it comes to private defendants, it's important to know who did what, who should have done what, who made did the wrong thing, and ultimately who's liable. And is it the doctor? Is it the surgeon? Is it the anaesthetist? Is it the theatre nurse? Who was negligent? And that will ultimately give one insight in respect of who should be sued. Now, that brings me back to the whole question of preparation, and that is why it is so important that at the beginning, that is before the particulars of claim even is issued, that it's already determined who the person or the entity is that is liable. Now, what is sometimes done is just to have a type of shotgun approach, and that is just join everyone. Then at least you can be sure that you have the right defendant before the court. The problem with that is that you are then joining defendants who you shouldn't be joining because they're actually not liable. And ultimately, that has enormous cost consequences because medical negligence matters are often very expensive. And the further you go into the process, of course, the more expensive it becomes. So it is actually quite dangerous to have included passengers on the bus that shouldn't be there because you have to pay for them and you have to pay to get rid of them, and that can be very expensive. That said, what you should also keep in mind is that there are instances where it is very difficult to determine who was negligent, who wasn't. You may be justified in not knowing. It's also possible that different people may blame another person. That is, the one doctor says it wasn't his duty to do something, the other doctor should have done it, and the other doctor reciprocates by alleging that it was the first doctor who made the hash. Now, in those circumstances, one would obviously then have to join both the individuals or entities. And in this regard, there's actually a useful provision in the rules. It is actually very seldomly used, and I hope I'll be telling you something that you didn't know. And that is the provisions of Rule 10, 4B, small Roman 2, that is 10, 4, small b, small Roman 2, and it makes provision for what is known as a bullock order. That is, in certain circumstances, it is possible for the court to make an order that the unsuccessful defendant should pay the cost of the successful defendant, which means that the plaintiff need not pay those costs. So you have two defendants. The one is held liable. The other one is found not liable, but it is possible that the court may then order the defendant who is liable also to pay the cost of the other defendant. Let's then briefly speak about the nature of MVA claims. Now, the claims normally fall into one or two, two categories or two possibilities, maybe even a combination of the two. But it can be, and it's possible that the plaintiff has a contractual claim, and therefore the normal principles relating to pleading a contractual claim would apply. That is, you have to say when and where the agreement was concluded and who acted on behalf of the parties, and whether it was oral and writing and that type of thing, the provisions of Rule 18.6 would be of application. On the other hand, the claim could be a delictual claim, and the usual principles relating to delictual claims would apply. I would now suggest that we deal with claims against state hospitals, which is possibly a scenario on its own. Now, I don't have to tell you, how to cite parties, and I'm not going to go into the whole question as to whether a man should be called man or male and that type of thing. I have sort of pet peeves about some of that too, but I'll spare you my views in that regard. But the defendant in the case of a claim against a state hospital is invariably the MEC of the relevant province, and that is so because of the provisions of the State Liability Act 20 of 1957. The MEC, or that medical department of that province, would also be an organ of state for purposes of the Institution of Legal Proceedings Against Certain Organs of State Act. If it's necessary to know, that is Act 40 of 2002. So the defendant is the MEC. Also, in terms of the State Liability Act, the summons actually has to be served on the local state attorney and on the MEC itself. So you actually have to serve the summons twice on the actual state provincial department of the MEC, and also on the local state attorney, that is the state attorney in the area of jurisdiction of the court in which you've instituted the action. Now, after you've dealt with who the parties are, some people would then, in paragraph 3, deal with jurisdiction. You can do that if you want. To me, that always looks like the way in which a pupil pleads. I would say things dealing with jurisdiction in my description of the defendant in paragraph 2, but you have to be aware that you have to say something about jurisdiction, and that applies to pleadings generally. It would then often make sense to describe or to give a reason why our plaintiff required medical treatment. How did it come about that he's or she is being treated by the doctor? Why does the patient get to end up in the hospital? The patient may have had previous surgery, or something, may have had a stroke, or may have something happened to the plaintiff, which meant that the plaintiff ended up in the clutches of the state hospital. Once you've described that, and that is difficult for me to deal with that in this presentation. Obviously the facts differ, and you would know what that is from your consultation and also from your expert reports. But once we then say that the plaintiff had this problem, we then get to the plaintiff goes to hospital and something happens there. The patient would be consult with someone. There may be some diagnosis of some sort. You'll say what that is, and there may even then be a recommendation as to what should be done. You'll describe that as well, and that is it's recommended that the plaintiff undergoes a laparoscopy, and then you say that is what had to be done. useful at this point maybe, and some people do it earlier already, is that you would then say that this hospital in which all of this has now happened falls under the authority and control of the defendant, that is the MEC. And you may also then want to say, because it's, as you'll see, is essentially a delictual claim, that the persons who were employed at the hospital were servants of the MEC and acted within the course and scope of their employment, so that we can establish vicarious liability. As I said, it's a delictual claim. And the reason, or maybe I should put it this way, because it's a delictual claim, you need to have a legal duty. There has to be a legal duty why these people who are treating the plaintiff, why they were required not to be negligent, and why they were required, and why the MEC is liable in circumstances where they were. And the sort of the current sort of easy way of doing that is to rely on the provisions of Section 27(1) of the Constitution. I think our colleague Pierre de Waal is the guy who introduced this approach first. But it does make it a lot easier. Section 27(1) of the Constitution says that everyone is entitled to proper medical treatment and also to proper emergency treatment. And once you've alleged that, a legal duty existed while the servants at this hospital, or medical staff, why they were required to act with due care. Then maybe very much the same way as one would have in the case of a motor collision, you then have to say, or deal with what, let's say, the state doctor did, or what he should have done, and that is, he did A, he should have done B, and therefore he was negligent. Or maybe it relates to the nursing staff, but this is the point where you will deal with that. Now, once you've done that, you then deal with the sequelae of what then had happened to the plaintiff after the negligent act had been perpetrated. If at this point the plaintiff had to undergo amputation, let's say, of his leg, then you would deal with those sequelae and with the damages which follow as a result thereof. I think I'll come back to this aspect a bit later. It is similar in all the different instances, and also in the case of other forms of claims. Let's then deal with the next set of defendants, and that is when it comes to claims against private doctors. Now, in this instance, we don't have Section 27 to rely on, because a private doctor is not required in terms of the Constitution to provide good medical care. And here the claim would be either a delictual claim, a contractual claim, or maybe both. Now, if you have a look at the precedence of pleadings, AMLA, you would see that there is actually no reference to a delictual claim in respect of private doctors there at all. And this may be a contentious aspect, but I'm going to deal with it briefly, although I'm not being as brief as I thought I might have been. But there is the whole dilemma or quandary arising from the judgment of in Lillycrap. It's it's maybe not quite coincidental that the name is lily crab. But it is a very difficult judgment to understand. I'm not sure that I understand it yet, and it may even be possible that we don't have to discuss this at all, but I'm going to deal with it very briefly nonetheless. If you need to know, the reference to the case is 1985, 1SA 475, Appellate Division. So the reference is 1985 1SA 475. Now maybe there, to distill it in some way, there are really two things that are important deriving from that judgment. And the first is that you cannot have a delictual claim against a defendant where it is necessary for purposes of establishing the legal duty, you have to rely on a contract. So if your defendant is not liable to you in delict, unless he entered into an agreement with the plaintiff, then your claim is a contractual claim, pure and simple, and you can't then also have a delictual claim. That makes quite a bit of sense, but the second principle is that where the plaintiff has entered into a contract with the defendant is entitled to accept that the defendant's liability is determined by that contract, and that he's not going to court out being liable in respect of some other delictual aspect, which is something beyond his contract. And generally, that also makes sense. You know, when you go for a ride at the water, on the water slide, and there is you considered to have entered into an agreement that the operators and the owners of the water slide will not be liable for their negligence, you can't then sue the defendant in delict on the basis that you still have a delictual claim. The problem then is when it comes to, well, maybe before we come to the problem, the dealing with the first of these two aspects, namely whether you need a contract to establish a legal duty. Now, in the case of suing a doctor, you don't, because the doctor is liable to you simply because he treats you, whether you had a contract or not. And authority for that is Van Beek versus Lewis, 1924 AD 438. So if you are found next to the road and you can't speak and you're unconscious and you're brought to a hospital, a surgeon does something and amputates your leg or whatever, then there's a doctor-patient relationship between you and the doctor, and in those circumstances, the doctor would be liable if the doctor was negligent, and there's no contract. So you don't necessarily need a contract to establish a legal duty in the case, as far as I'm concerned, of a doctor. The problem maybe is in respect of the second leg, and that is, if you have a contract, which mostly patients have, they have a contract with their doctor that the doctor would perform the surgery and the patient will pay him for that. So you virtually invariably would have a contract. The question then is, can the plaintiff only sue the doctor contractually? And there may even be people who think that is the case, and I've seen the odd operator dictum which seem to imply that. But the dilemma actually that arises in these circumstances is the following, and that is, there are quite a few judgments. The first is Administrator Natal versus Eduard. The Eduard is spelled unusually, it is E-D-O-U-A-R-D Edward, that is, the citation is 1993 SA 581 Appellate Division, where the court held that if you have a contractual claim, you can't claim general damages. So you can only claim general damages if you have a delictual claim. So the difficulty then would be that if you can only sue a doctor contractually, what about your delictual claim? Now, my interpretation of the case law, and also a sort of a one-line snippet in the judgment of Janssen van Vieren versus Kruger, that is 1993, 4 SA 842. It's also a judgment of the Appellate Division, and particularly on 849 A2C. Did I say that the page number where the case starts is 842? That there is no reason why you can't sue a doctor delictually. And what I actually normally do is I use both, and I don't even do it in the alternative. I say that you had a contractual liability and you had a legal duty, and you breach both of those, and therefore you are liable. Now, in all the matters that I've done, it's never happened that the defendant has said that I can't do that because of the Lillicramp judgment. So I'll leave it to you as to how you want to approach that. Now, when it comes to claims against private hospitals, that really is by and large the same as claims against doctors, save obviously, as I've indicated, that it is necessary to allege that the nursing staff acted in the course and scope of their employment. I'm going to deal very briefly with the question of damages and the sequelae. Maybe it's not necessary to say that much about it. The first thing is that, in my view, you should never, ever do this by simply annexing a report. It's horrible, it's wrong, it says more than it should. It is not proper pleading, it is lazy. Don't do it. It is necessary for you to make proper and detailed allegations relating to sequelae and damages. And it is necessary to deal with it probably under at least the following headings. The one is past treatment. The next is future treatment. And in this regard, keep in mind that in the case of medical negligence, there is no undertaking for the payment of future medical expenses as you would have in MVA claims. The next topic is probably past pain and suffering, the next future pain and suffering, and then past and future loss of amenities, past and future disability, and past and future disfigurement. That roundabout would constitute the things that you are required to say. I think I may have forgotten, although I dealt with it earlier, is that when you sue the MEC, you also have to allege that you complied with Section 3 of the Organs of State Act. Now, that by and large brings me to the end of my presentation. I'm now going to say something that I actually wanted to say in the beginning, and that is to say that I'm really very grateful that I was given the opportunity of making this presentation. I want to thank Bart Ford and his crowd for inviting me. And I also want to express my appreciation for the fact that these presentations are done on a weekly basis. I think it will help many people enormously, even if whether or not you found any benefit from from my presentation. But I then also simply have to add the following, and that is that obviously when I was a rank junior, more senior people also assisted me, and the one person in particular who helped me a lot was a chap called Avi Mizrach. He assisted many juniors enormously. And I said to myself at that time, I may never, ever forget this. And when I get more senior, it is of utmost importance that I repay what he's done for me. And I would urge you all, when you are a lot more senior or you have the opportunity to do so, to also assist other people the way that you have been assisted on your way to become more proficient and more senior. Janine, thanks. It's over to you. I'm finished. Although maybe it's not Janine, it's do I have to face questions now?
Yes. Thank you so much, HB. HB, indeed, it's an honor to have you. There's a question from Maud Letzler. Maud, you can simply unmute your mic in. You can simply unmute your. There you go. You can simply unmute your mic.
Thanks, Omek. Okay, HB, are you ready?
Now, don't ask me anything about lily crab.
No, I think I want to start by firstly saying a welcome. I see JP Ellis is on here. JP is from Ethical, and I think he's listening to what all of us are going to put in our particular, so he can defend those claims going forward. But then secondly, to completely agree with you, HB, when you say that we need to pass on information and knowledge, because paying it forward, I think, is the most important thing. Then the question I have for you, and I think this is something that all of us that moved from RAF matters to medical negligence matters, or like I sort of jumped into medical negligence before RAF, but what is, if you have to summarize what is important between liability and causation, and I think this is the biggest difference if you go from doing road accident fund matters to doing medical negligence matters, is how to plead and how to prepare for liability and causation, either individually together or together, and what the importance of those two legs are, because you can succeed on liability and lose on causation. So if you can just maybe explain to everybody how to deal with those when you're pleading and how to deal with those when you're preparing for a case.
Yeah, the easy answer to that, Maud, is that the question that you've asked me now, you asked your medical expert, and you will be asking your expert. You say, because you know, and Lily Crapp's judgment is also authority for this, and that is that the mere fact that a doctor was negligent doesn't mean that he's liable. And part of that also relates to the whole question of causation. But what you are going to obviously have to say in your particulars of claim is, this is what you did, and whatever you did or you didn't do resulted in something else happening. You know, so that compromised the blood flow or whatever, and therefore the plaintiff needed an amputation. But maybe from a pleading point of view, it is easier just to say that A was caused by B. It is often more difficult to prove that, you know, when you get to court. But it is a difficult aspect, but the easy answer is your expert would have to get you there. Is that okay?
Thank you so much.
Thanks, actually. I think it ties in with what you said earlier on, is that the difference between RAF matters and medical negligence matters is that you have to have an expert report before you start, because you can't plead liability and causation if you don't first have the input of an expert. So you don't first plead and then go to an expert. You go to the expert first and determine if you have a case, not just on liability, but also on causation.
Yes, in fact, apart from that, you also have to know that you have the guy. I mean, you at least you then have someone who you can assume would be prepared to testify in the matter, and that's sort of part of the problem, is that when you get to be a month or two away from the trial, now you're looking for an expert and no one's prepared to testify, then you have a problem already. But you actually need to have secured your experts. You need your team ready. That is the only way in which you fight a war. Okay, is there another question?
Thank you, HP. There's a question from Mohammed Patel. Mohammed, you can simply unmute your mic.
Afternoon, Council. It's a pleasure seeing you again.
I feel the same way.
Council, I have a question pertaining to liability. With the current vaccine drive and that's ongoing due to this pandemic, and we all know that there's various reports about the different vaccines, such as the Johnson & Johnson vaccine, that is creating blood clots within in the individuals that are receiving it. And according to my research, I've seen that to make a vaccine, it normally takes between 3 to 10 years for a vaccine to be made. And obviously, with the current COVID vaccines that are out there, it was made in a very short period of time. So I think down the line, in the next couple of years, we're going to have lots of results and damages from the vaccines that are coming out. So my question is now, will the government be held liable? And should we be citing the Minister of Health in our particulars, or should we be citing the pharmaceutical companies that are bringing in the vaccine? And that's something that I'm trying to grasp. Or should we perhaps cite both parties to our particulars of claim? Thank you.
Yes, have you noticed how good counsel is not to answer questions? We always, when we cross-examine, we accuse witnesses that we're cross-examining from not answering the question. But I'm not sure whether I'm going to do that now. But ultimately, the topic of our discussion is how you should plead, not who is liable. That's your question more relates to medical negligence rather than how do you plead it. But I would imagine that we in a situation where ultimately no one forces anyone to have a vaccine, and maybe it's even possible that we all know that it takes a lot longer to generate a proper vaccine, and I assume that we're taking a certain degree of risk in the process, but it's going to be interesting down the line how that's going to pan out. I've also wondered about that.
Thank you, Council. I really appreciate your answer.
Thanks, HP. There's a question from Taylor. Tyler, you can simply unmute your mic.
Yes, hi. I don't know if you can hear me, please.
Okay.
It's a pleasure to put a face to the name, Council, but I wanted to ask, you said that by pleading in the sequelae, don't ever attach a report. It's lazy pleading. Is there any, I know that it's a preference of yours in terms of pleadings, but is there any case law that states something like that? Or I'm pretty sure judges just look down on it anyways, but is there any reference you can give me for that?
Yeah, there is a well, the approach is that it is not a proper way of pleading, but you will find that there's authority. I know that Goody Gordon gave a judgment sort of a bit on this topic many years ago, but I don't know the case's name off by heart. But the idea really is that the defendant, if you make an allegation and you then say all these things, all these sequelae you'll find in this report, that means the defendant then, to determine what you're actually saying, has to work through this report to find what you're saying about that. And it's not structured properly. And there often is, you would find a lot of gumph in a report that has nothing to do with the sequelae. You know, the doctor says, gives a whole list of things that documents that he received and interviews which he had, and so the report would often deal with aspects that are just simply not relevant. And the suggestion is that a defendant, you can't leave it to the defendant to go and find what you actually should be alleging in the first place. So, and the authorities would also then suggest that at least what you should do is, and this may still work, if you say that the plaintiff underwent the treatment set out in paragraph 14.5 on page 3 of the report. That could work. So if you tell the defendant where to go to in the report, you could get away with it. But it just looks like not very professional. I think it's more than simply my personal sort of view about it. But I don't think you should do it.
Would that mean that the pleading is deemed acceptable, though? Because I mean, if you can't be expected to plead to every averment made in the report, so surely that the defendant would be able to accept it.
Yes, it could be vague and embarrassing. Just by the way, Janine mentioned that I'm Afrikaans. For those of you who are Afrikaans, did you also have the problem when you were at varsity and you read about vague and embarrassing? I never understood why it's embarrassing. I mean, it's not like you're caught with your pants down or something. But yes, I think the embarrassing thing is that you're embarrassed because you don't know what to plead to. You know, that gives you that feeling of discomfort.
Thank you so much. I appreciate the answer.
Okay, not at all.
Thanks, HB. There's a question from Lossie. Lossie? Lossie, you can simply unmute your mic.
Doris, good enough.
Hello, Doris.
Hi, hello, HB. Thank you very much for that very, very helpful talk that you did.
Yes, most people, I don't know.
Okay.
Doris, I do know, and Henk Low, I know. But hi, Doris, are you well?
Yes, thank you, HB. I hope you're well too.
And thanks.
My question is, in cases that are not medical negligence cases, as I understand our law, the language of a duty of care is from the English law and has no place when you're pleading the Aquilian action.
Correct.
Why is that different in medical negligence cases?
No, it isn't.
So you not have to say there was a duty of care.
No, in fact, you may have noticed that what I said is I called the legal duty.
Yes.
And in that judgment of Anton Mostert in something with Tommy Meyer versus the University of Pretoria, that's the judgment in which he first said that it's not a legal duty. I mean, it is not duty of care, it's legal duty, but legal duty is also the what is required for purposes of the delictual claim in medical negligence to establish a wrongfulness.
Thank you very much. I appreciate it.
Good.
Thank you, HP. There's a question from Kerry Williams. Kerry, you can unmute your mic.
Hi, Advocate Marais. Kerry Williams here. Apologies for not... HP, Kerry then. Apologies for not putting my camera on. I'm not in chambers, but I wanted to ask you if you could speak about your experience of defending a negligence claim, and particularly the defense that the practitioner made a reasonable error of professional judgment. I asked the question because I understand there's quite a subtle distinction between being negligent and making a reasonable error of professional judgment. And I'm wondering if you could tell us about your experience in that space, if at all.
Yes, I don't know how much experience I have of that, but the important thing is in dealing with it is there's a concept known in Formula One racing and other racing too called a racing incident. I find that quite useful to explain the concept. And that is, you have two motor vehicles traveling at 300 kilometers per hour down the straight, and there's a hairpin bend at the end thereof. And you have these two motor vehicles going hell for leather, and they're close to each other, and a slight error can happen. That is what happens. And that, sorry,
just what we can post.
Am I speaking to myself or?
No, we can hear you.
But one can. You have a situation that in the heat of the moment, when you are going as fast as you can, it is conceivable that even someone who's driving well can do something which can have terrible consequences, and that can happen with a doctor too. You're on the horns of a dilemma. You have to make a decision, and it is possible that in deciding whether to do A or B, doctor can choose the less than perfect option in the circumstances, but that would not, that is, to put it differently, an error which a reasonable doctor could have made. Yes, it is possible that under those circumstances that the practitioner might not be liable.
Thank you. May I ask a follow-up question?
All right.
I'm cheating, really. It goes to pleading legal duty against a private practitioner again, and I certainly have struggled with articulating the content of that duty. It's much easier, as you say, against the state with resort to Section 27 of the Constitution. But the content of the legal duty against the practitioner seems to differ widely depending on the type of practitioner you're dealing with, whether it be a general practitioner on the one hand versus a surgeon on the other. And it feels like in some ways we're making it up as we go along in relation to that content of that legal duty. Again, just from your own personal experience, when you are trying to determine the exact contours of the legal duty vis-a-vis the private practitioner, how would you go about that?
I think the difficulty doesn't lie in the legal duty. The legal duty would arise from simply the fact that the doctor had a contract with the patient, or was treating the patient, and there's a doctor-patient relationship. So we now know that under those circumstances, the doctor has a duty, shall we say, not to be negligent. So the doctor has a duty to render proper medical treatment. That part is easy. The part that becomes difficult, and I think that's where your question is directed towards is really the question of negligence, and that is where do you set the bar for this practitioner? How low or how high is it? So what are you expecting of the practitioner to be able to do or to know or to? So, I mean, it is possible that if something was done by a general practitioner, he may be regarded as not negligent because the bar is lower for him. But then if the practitioner wasn't a general practitioner but was a specialist surgeon, the bar is higher. And therefore, when it comes to the question of what a reasonable specialist surgeon would have done under the circumstances, that test is a lot more, is more strict test than you would have otherwise. And there, you're quite right. There it can become quite hairy as to where you draw that line. But again, that isn't necessarily a pleading problem, but it is a question of onus of proof problem.
I'm sorry, may I add here and interrupt just to answer Kerry's question as well from what HB has said, Ahmed?
That's fine, Maud, that's fine.
Okay, Kerry, firstly, the Health Professions Council's Code of Good Conduct, and as it goes to the ability of practitioners to perform in a particular way, doesn't specify that for instance, obstetrician is the only person that's allowed to do obstetrics. So if you plead for, say for instance, you have a GP that performed a cesarean section in the sticks, and he's the only doctor that was available, and he's done many of those, then he's not going to be held liable for the fact that he was negligent simply because he was a GP. He can still prove that he had the necessary skills and qualifications to do it. In other words, the Health Professions Council does not preclude any doctor, even if he is a GP, from performing the duties of a surgeon. And that is what I said earlier on, that is so important, that when you plead the legal duty that you should already have. Sorry, Sibusiso, I think it's your mic that's making so much noise because it keeps on flaring up. And I can, yes, thank you. So basically, when you plead the legal duty, you plead it as if a doctor with that specific skill and knowledge would not have done similar to what this doctor has done. And then you're looking at adverse outcome, you're looking at complications, and you're looking at negligence. And only the last one really gives you a claim for damages. So you will plead it according to what your expert has said. And that's, again, what HB has said earlier on. You cannot plead a particulars of claim without being in possession of an expert report, because your expert report will set out for you in detail what it is that you have to plead that was negligent. If you go in there blind, then you basically have to go and Google it yourself. You have to go and check. Say, for instance, to give a stupid example, to go back to obstetrics. The woman gave birth, the child has a lack of oxygen, you sitting with a hypoxic event. Now you have to go and Google it yourself to see what it is that you think that doctor should have done to plead in those pleadings that it should not have happened. Whereas if you had a doctor's report from an obstetrician, or even if it was a deep GP that does obstetrics, say for instance for the defendant, you can set it out exactly what should or shouldn't have done in your pleadings or in your plea, but you cannot do it without the input of a doctor.
Yes, thanks, Maud. Thank you.
Thank you for that. Maud, I have, sorry, HB, I have a question for you.
Oops.
I understand the address today is surrounding the pleadings around medical negligence. However, as it is commonly seen within the hospital consent forms, particularly within private hospitals, which needs to be signed prior to admission, both you and I know that such consent forms serves as a comprehensive indemnity contract between the patient and the hospital and the treating doctors. It is my submission that such consent form is the first hurdle to cross, which hospitals and doctors seem to hide behind the so-called doctor's veil, which is indeed difficult to pierce. To treat competent patients without their valid consent is a violation of their constitutional right and transgresses a fundamental principle of medical law. The basic rule is simple. No one has the right to touch anyone else without lawful justification, and if doctors do so, it may well undermine patients' trust as well as violate their rights to physical integrity. The only exception to this rule is when the patient lacks the capacity to give valid consent, in which case someone else has to make decision on behalf of the patient. What is your opinion on that, Advocate HB?
I'm not aware of any instance where a doctor has included in an indemnity in the agreement that the doctor has concluded with the patient. I mean, that might happen. I don't know. But you're right. I've seen instances where the hospital, they have exclusionary provisions, which says that if their staff, anyone was negligent, they're not liable. And I've also seen them plead that. But what I've done under those circumstances is there's a judgment by Carolyn Nichols, where she's, when she was still in our division. And I just don't seem to be able to remember the case's name. But that relates to the question of these exclusionary clauses. Sorry, my phone's just ringing. I just want to get rid of it. You might not be able to hear it. But just sort of briefly dealing with the facts of the case. A guy, or the plaintiff, stayed in a hotel. And he was a guest in the hotel, and he, I think one morning he went out to the back of the hotel where his car was parked in the hotel's parking area, and he wanted to leave, but he couldn't leave because the gate of the parking area was closed. And he and I think a security guard then tried to open the gate, and the gate toppled over on top of him and injured him. And he then sued the hospital, and the hospital relied on this indemnity in the agreement. What the court found is that, in the first place, that there are instances where you don't expect, and you're entitled to expect, that you won't be hurt. I mean, you're not thinking that if you go to a four-star hotel that you're going to be injured. When you go to Sandton City and you walk along the corridors, you don't expect that you're going to, to trip and fall or something. There are certain instances where you're entitled to feel safe. This is not the case where you go and bungee jump or skydive or go on a water slide or something. There one can see that you're assuming some kind of risk. Now, she then found in that matter that that was a limitation that was unconstitutional, and that sort of fits in what you are suggesting. Now, I've pleaded that when you undergo surgery or you go into a hospital for treatment, you're entitled to expect that no one's going to be negligent. You're entitled to expect that if something happens to you, it's because of your condition, not because someone else messes anything up. And that those type of exclusionary provisions in the hospital agreement, that's also unconstitutional and should be regarded as pro non scripto. Now, I've replicated that on a few occasions. I've never actually gotten, none of those matters has ever gone to court so that it was necessary to argue. So I can't tell you what the outcome would be, but I think that is the law, and I don't think those provisions are enforceable.
Thank you so much, HB. Over to you, Janine, for the conclusion.
Thank you very much, Ahmed. Just want to say thank you, HB, for the very insightful talk and for sharing your time and knowledge with all of us. I especially enjoyed the practical tips and the pet peeves to avoid. And I'm sure that everyone here will leave the session with a better understanding of the law in the area and how it should be pleaded. Thank you also to the South African Bar Association for the opportunity to be a part of this initiative. Good evening, all.
Thank you. The only thing that remains for us is to thank Advocate Janine Khan for revealing the mystery behind what HB stands for. Appreciation to HB Marais SC for his profound address, Advocate Janine Khan for a pleasant welcome and conclusion, and to all those that have participated virtually. These sessions are recorded, and the recordings can be found upon the South African Bar Association website, that being www.rsabar.net. Once again, thank you, and it is always a pleasure. I thank you.